Okay, so thank you for coming today to our new knowledge session. One of my old and dear friends, Ramesh Murthy with Penn Stuart, will be talking to us about business law. This is our series that we began several years ago, and the quality of our education just keeps getting better. So without further ado, Ramesh Murthy, employment law.
Thank you, Kathy. I saw the flyer out front, and I had not seen that before, and it seemed to provide a more broad-based discussion of employment law. But really what I want to focus on today is three areas of employment law. There are so many areas that, quite honestly, it's a minefield. And if you're in the human resources field, in particular, when it comes to employment law, sometimes it baffles me how human resource professionals are able to navigate the myriad of laws that are in place, because it truly is a minefield. By way of background, I am Ramesh Murthy, so at least I'm at the right place. I'm with Penn Stuart. I've been practicing law, this is where Kathy and I are old friends, for 26 years with Penn Stuart, 26 years total. And my area of practice is actually limited to employment law. We're fortunate at Penn Stuart in that we all have our own little bailiwick, our own little areas of practice, and that's all I do, which is disheartening to folks like my father, who may call me from time to time. He's a retired physician with some legal issues. Like, can you draft this contract for me? And I'll say, you need to hire a real lawyer for that, because I'm not the right person for that. All I do is employment law. That's really all I know. Now, in deep Southwest Virginia, or Southwestern Virginia, a lot of employment law, for good or bad, encompasses workers' compensation law as well. In fact, I would say a bulk of employment law practice around here in terms of litigation is workers' comp based. We certainly have our share of cases under Title VII, which is discrimination, or the ADA or FMLA, some Fair Labor Standards Act matters as well. But a lot is intertwined with workers' comp. We have 40 lawyers. I don't know how many, we have 5 offices, but we actually have 15 lawyers that do workers' compensation defense work. And I would like to say that's because we're so good, but the reality is it's because there's so much. There's a real need and we do defense work. I only represent companies, and I've only ever represented companies. I've represented one lady. It's the gift that keeps on giving, because I still have her as a client. And she's great, and I love helping her, but anyway, but generally it's company related. Now, as much as like every lawyer, I love to hear myself talk, but that would be so boring to all of you. So I would certainly invite participation, any questions at any time. If you disagree with me, that's fine with me too. Let's talk about it. Let's try to figure out answers. Because what I'm trying to do is let you guys know what the landscape is. And now, even though I've been doing this for 26 years, I don't claim to know all the answers to every question in this field, even in the field that I've been practicing in. But I think that's where a dialogue is important. And so, any questions, any comments? If you want to yell out, you're wrong, that's fine, and we can talk about it. But the focus of the presentation is going to be, or is, on basically the interaction between the Family and Medical Leave Act, the Americans with Disabilities Act, and honestly workers' comp, because there is a big interplay. Now, as you know, workers' comp applies to basically if you have 3 or more employees or 5 or more employees, depending on what state you're in. It applies to all of you. You have to have workers' compensation insurance or go through the framework to become self-insured, which is unlikely. I mean, you have to be a pretty big organization to be self-insured. So you have to have workers' compensation insurance.
Okay, so that's the first question.
Okay.
When you say 5 or more employees, are they part-time? Does the law say that they're part-time, full-time, a combination, or does it have to do with how you require them to come to work?
It's actually 5 or more regularly employed employees. So even if they're part-time, if they're regularly employed, they fit within the framework of workers' compensation.
So if they come to work from 8 to 10 every day.
If they're regularly employed. Now, Now, there are all kinds of exceptions for agricultural workers or for seasonal employees, and we can talk about all that, but generally, that's the rule, is if they're 5 or more regularly employed. Now, that's important because if you don't have workers' compensation insurance, the workers' compensation is handled by the Virginia Workers' Compensation Commission, and there's actually a specific act in the Virginia Code, which is the Virginia Workers' Compensation Act. And it outlines, they're the ones that enforce the workers' compensation laws, at least at the initial level. They're the ones that have an insurance department. They have a database that they collaborate with NCCI, which is a national organization, to try to keep track of who's insured by who and who's not insured and things of that nature. And it's important because it used to be that if you weren't insured, you got called to a show cause hearing and you were subject to a fine of $5,000. Well, that has changed. It is now $50,000. So it's a significant difference. And I deal with a lot of insurance people, which are generally great, but I will be honest with you, I have seen a lot of bad advice being given by some brokers in particular about who needs coverage and who doesn't. And sometimes it may be beneficial to reach out to your lawyer, whoever that may be, just to get a second opinion on whether or not you need coverage or not. Because, for example, if you, I had this situation, someone's building a house and they subcontract it all out. But if you count everybody there under the subcontractors, there are probably 20 people on site at any one time. And what the commission looks at is how many people are involved in that project. And even though you may call them all subcontractors, if you're overseeing the project and you're delegating, you're telling people how to do things and what to do, you may be deemed the employer. So it would make sense to go ahead and get workers' compensation insurance instead of trying to contract it all. It may be by contract anyway, but just because you call them an independent contractor doesn't necessarily mean they are an independent contractor if you are directing them. And that's really the critical. Who has control over them? Yes, sir.
We represent the church, and as such, we're a nonprofit. So could you, as you talk, point out anything that might not apply to us or
Sure.
does apply to us?
Yeah, and that's another minefield. But I'll be happy to try to do that. So I don't want this. Yes, sir.
You mentioned about building a house. You still get the insurance. How much are we typically talking about the cost of something like that?
That's a great question, and one that I do not know the answer to.
Is it $1,000 or 10,000 or $200?
It's based on payroll.
It is based on payroll. They do a payroll audit.
But in that case, you're not. You're subbing it out.
Well, you can certainly get it. Here's what I would do. I would certainly the first thing I would do is for all your subcontractors that show up on site, I would make them bring you a certificate of insurance from their particular carrier, so that you know if one of their folks gets hurt that there will be coverage there below you. And then I would take all of that to your agent and say, here's what we got. And I think you're going to get a much cheaper product at that point if you do that, if they know that there is insurance in place. The problem occurs when people show up on site and start doing work, and then you find out that no one is insured. And then who's ultimately going to be responsible? It goes up the chain to you.
Okay, you mentioned that, and speaking of this case, is that a seasonal issue? Is that something that you could get a policy for a certain length of time or so many months?
That's a good question too. I honestly don't.
You're not building a house year in, year out.
No,
You're
yeah.
always going to have those same employees or number of employees.
Well, he's talking about the contractor himself.
Right, the contractor himself, but even the contractor himself with his subcontractors, the number is going to change and the payroll is going to change.
Yeah, and it depends. You could be if you're in the business of building. If you're building one house, and that's all you're doing, that may be a different situation than if you're a builder, but you're trying to. A lot of people try to do it on the cheap, and they don't want to get insurance because they don't want to pay for the insurance. But they figure out if they subcontract everything, then they don't have to pay for that. And I guess what I'm saying is that's a huge pitfall. Now, the insurance agents would have more information as to how. Generally the policies run for a year, and if you're going to keep in that business, then I would do it for a year. The other question, I guess, is if you mean, you can cancel your coverage at any time. So if you get coverage and then you don't need it anymore, you can cancel that coverage, and obviously that would affect what you'd have to pay for that coverage, or you may get a refund for that coverage. But again, an agent would be more, you know, we don't get too much into the billing questions than we do just the legal questions. We get called when someone gets hurt, unfortunately. And I've seen some significant injuries. I've seen some trivial ones too, that they make out to be significant. But I've seen some, I mean, I had a case recently where a guy was building a house and is a quadriplegic now. He fell, and it's just a horrible situation. Now, I don't want to make this workers' comp central or centric, but we can if you want. Because I will tell you, I would say at any one time, I have 500 cases, workers' comp cases, at any one time. I mean, it is a huge, and I'm blessed to have a lot of big clients, but that's a lot of hurt people. So I always say it's good for me, it's bad for society, and that's, I mean, honestly, the truth. But getting back to the topic at hand, how many of you have, well, 25 or more employees, or 50, how about 15 or more employees? Okay. How about, I know you. And how about 50 or more employees? Okay. And the reason I ask that is because some of these laws only apply to you if you have a certain number of employees or more. For example, the Americans with Disabilities Act applies if you have 15 employees or more, so you'd be covered by the ADA. So you have to comply with the ADA. Family Medical Leave Act, it's a stringent set of requirements, but it's really 50 or more employees. Whether you have 50 or more, I think it's important to understand what these laws mean and what your responsibilities are under these laws. How many of you have familiarity, maybe great familiarity, with the Americans with Disabilities Act? Okay. It is interesting, I actually have a special needs son, and it's kind of interesting that it's the one area where I actually know how to help my son somewhat. And it's, if you're not involved in it, you really don't understand some of the needs of folks that do have disabilities. And for example, I had to build ramps at my house because of my son. I don't even know how to get a ramp built, but I get a contractor, so I'd get some insurance. But the Americans with Disabilities Act first of all, it is enforced by the EEOC, or the Equal Employment Opportunity Commission. And just as a 30,000 feet view of it is, what the purpose of the act, and I'm referring to Title I of the act, which deals with employment, is basically the act is designed to make sure that folks with impairments or disabilities are not discriminated against in the workforce. That's a broad brush view of it. So that folks that have impairments or disabilities are able to work and are able to use, you know, if they want to work and they are able to work, that they are able to work and they're not simply shut out of the system because of their disabilities or their impairment. So in that regard, it's a very, I mean, I think it's a great act from that regard. The problem is the devil's in the details, and compliance is very difficult. And you really have to know what you're doing in terms of being compliant. Now, under the Americans with Disabilities Act, an employer is required to provide reasonable accommodation unless doing so would impose an undue hardship on that employer. A reasonable accommodation is a change in the workplace that enables an employee to perform the essential functions of his or her job. So, first of all, you have to know about the disability or the impairment, which raises a whole other set of questions. Because when you actually are in the interview process, you really can't ask those questions about whether they have a disability or an impairment. But what you can do is, and what's important, and the important phrase in the Americans with Disabilities Act world is, are they able to perform the essential functions of the job? So, and I don't want to get into a detailed discussion of the screening process, but if you hire somebody, if you have an application process, on that application, you cannot ask, do you have any disabilities? But So, which, for the reason that you discriminating, just hire that individual knowing that they have a disability. But you can't performing, and you can actually ask. For example, it's a show you. You can take it out to the job site and say, "Can you show me how you would, how to do this? Here are the essential functions of the job. Would you have any problem doing any part of the essential functions of this job?" You can do that. You can also, and I would recommend it, even though it's sometimes cost prohibitive. Once you get an offer to you, it can be conditional on a post-offer physical examination, which means you send them out for a medical evaluation for the purpose of determining if they can perform the essential functions of the job that you have made an offer to them. You can't do that before, it's called a post-offer evaluation. You can't do that before you make an offer to them. You can't screen them by doing the evaluation, but you can make an offer to them contingent upon them passing the evaluation or getting clearance from the physician or the healthcare provider that they're capable of performing that job. Now, getting back to workers' comp for a second, it is a big issue in workers' comp. In fact, I just wrote an article on this that was published because in Virginia workers' compensation follows the rule: you take your employee as you find him or her. It was written in the 40s, so it says him. But what that means is, for example, you hire someone that has a significant back problem, and you put them in a job that requires them to use their back. And let's say they do something to hurt their back in the job. Let's say, and I don't want to get too medically specific, but let's say they have significant degenerative changes in their back. You put them on a job, they have a strain, but the strain aggravates these significant degenerative changes, and now they're disabled. So the injury actually made symptomatic the pre-existing changes in their back. Under Virginia workers' compensation law, that is now yours. You have to pay for that. And the premise of the article that I wrote was, 40s, not this political statement about whether it's right or wrong, but in the 1940s, 50s, and 60s, that was fine because it was a little more footloose and fancy-free when you were interviewing folks. You could actually ask them questions about, do you have any back problems? Do you have? Now, from a federal standpoint, you're prohibited from asking those questions. But now, if someone has an accident that aggravates a pre-existing condition, you're now stuck with that. So it's basically the federal law is saying you can't ask questions, but the state law is saying you're stuck with what you got because it's a pre-existing condition. You hired them knowing they had a pre-existing condition. Well, you didn't know. Change in that regard. I'm not smart enough to figure out how to change it to make it compliant. But that is the current state of the law. So that's why these post-offer physical examinations may actually be helpful. And again, they're cost prohibitive. In my world, the best thing would be to have someone undergo a whole body MRI scan, which would be great, and then you know everything post-offer. But that's not going to happen for the obvious reasons of cost and just putting people through that.
All right, but if you did do that post thing and they didn't perform something, they couldn't do something or they couldn't do whatever it is you wanted to do, then you say, okay, thank you, and now you didn't get the job. Are you exposure at that point, and you're saying, no, they couldn't perform it?
Well, you're hiring them to perform the essential functions of the job. I guess one thing you could look at is there a way to reasonably accommodate them in terms of performing that job? Which gets into a whole other area of
if they go lift 40 pounds and consequently they couldn't lift 40 pounds, you said, well, you're out.
No. I mean, honestly, my view would be, yes, if they're not able to perform the essential functions of the job at that stage, I would say you're out. You can certainly do an investigative search as to whether or not they can perform the essential functions of that job. But, yeah, that's what you're testing them to determine if they're capable of performing the essential functions. And if they're incapable, then the offer is contingent upon that. So, yeah, I would take the position that, and I think you've done what you're supposed to do in that regard.
And should you put some of that in your job description, like I'm supposed to 40 pounds?
Absolutely. In fact, I would recommend a pretty detailed job description. And in fact, and as an aside, the other thing I would put in my job description is arrive at work on time, things of that nature, is capable of, arriving to work at the designated time and working for a designated shift. I mean, all of those things are important in your job description. People don't think about that, but that is important. And I'll talk a little bit more about the Americans with Disabilities Act as we go along. The Family Medical Leave Act, on the other hand, well, let me get back to the ADA for a second. The ADA not only applies to folks that have a disability, but it also applies to folks, and this is where it gets confusing, folks who are perceived to have a disability. And I'll give you an example. I had a case representing a dynamite company, and they had trucks that would haul dynamite here and there. One of their employees had a heart attack, and eventually, after treatment, he was cleared to return to work. The employer was concerned that he would be driving a dynamite truck somewhere and would have another heart attack. So they did not take him back to work. They got sued. He wasn't saying he was disabled. In fact, he was saying, I'm fully capable of returning to work. In fact, I have a clearance from my doctor. The employer, on the other hand, was prohibiting him from coming back to work because they were concerned. They essentially perceived him as having a disability or an impairment. And that produced a lawsuit. And I can tell you, that's not a good situation to be in. If they're cleared from their physician, and I understand the ramifications of it, but if they're cleared by their physician, then I think you're treading on thin ice if you tell folks you can't come back to work, if in fact they have been cleared by their physician to do so. Of course, the dynamite company is saying, I'll take this to a jury all day long to say, this man that's had a heart attack and has a significant heart condition, even though he's been released, do you want him driving a dynamite truck through your neighborhood? That was their theory. And I said, well, that's all well and good, but you're probably going to get popped by a jury because he has been cleared to return to work.
Did he go to jury? Go to trial?
No, it went to settlement. Now, the Family Medical Leave Act, switching gears for a second. How many of you are familiar with the Family Medical Leave Act? Everybody? In general terms, it provides leave to certain employees who are experiencing serious health conditions or who need to care for a family member. So it differs from the Americans with Disabilities Act. It actually it provides eligible employees with benefits that they may exercise, and you may ask them to exercise when circumstances dictate. Whereas the Americans with Disabilities Act is designed to provide equal access opportunities to employees with disabilities. Again, the Family Medical Leave Act applies to employers with 50 or more employees. And there are certain other requirements in terms of how long they had to work there, and I'll be happy to go through that with you. They must have worked for at least 12 months. They must have worked at least 1,250 hours during the 12 months prior to the start of the family medical leave, and work at a location where at least 50 employees are employed at a location, or if you have several locations within 75 miles thereof. So they may combine locations if you have another location 75 miles or less away. Now, and I don't want to get into a detailed discussion about this, but there are different ways to calculate that. You can calculate this year as a fiscal year. You can calculate it as a rolling. There are different types of ways to do that, and you just have to, consult with your counsel to determine exactly what's the best way for you to do it. Most folks do a rolling 12 months to keep track of this, because someone could start on leave November 1st, or how about December 1st, and then if it's a fiscal year, then basically they're entitled to another 12 weeks, January 1st. If your year is January 1st to December 31st. Under the Family Medical Leave Act, a covered employer must grant an eligible employee up to a total of 12 work weeks of unpaid leave in a 12-month period for things like the birth of a son or a daughter, the placement of a child with the employee through an adoption agency, the care of an immediate family member, one's own care, therapy, recuperation when unable to work because of a serious health condition. And you should know there are also some other things were added on. One is when issues arise when a family member is a member of the regular or reserve components of the armed forces is deployed to a foreign country. You can take leave under the Family Medical Leave Act if you have a family member that is deployed to a foreign country. If you are a veteran, the FMLA allows for 26 weeks of unpaid leave for, or if you have a family member that's a veteran, for family members who are veterans and in need of medical treatment. So if you have a son or a daughter or a father or mother that's a veteran and they need care, you can take up to 26 weeks of unpaid leave under the Family Medical Leave Act. Now, what is a serious health condition? It means an illness, injury, impairment, or physical or mental condition that involves any period of incapacity or treatment connected with inpatient care, or a period of incapacity requiring absence of more than 3 calendar days from work, school, or other regular duty activities that involves continuing treatment. Any period of incapacity due to pregnancy, any period of incapacity due to a chronic serious health condition like asthma, diabetes, epilepsy, a period of incapacity that is permanent or long-term due to a condition for which treatment may not be effective, like Alzheimer's, terminal diseases, some strokes, things of that nature. Or absences for multiple treatments, including recovery periods. This is the government at its best, but any absences to receive multiple treatments by or on referral by a healthcare provider for a condition that likely would result in incapacity of more than 3 consecutive days if left untreated. Can anyone tell me what that means?
This is the part I've always had a question about that. What is the difference, or when is one trigger versus just forever? I'm taking sick leave. You know, I've got my bank account here for that, and I'm gonna be gone for more than 3 days, or 5 days, or even 2 weeks. Versus, then I've got to apply for this particular leave. When does one trigger and one impact, or do you can?
Yeah, I mean, if it's like a cold or something like that, that's one thing. If it's not going to require 3 days of leave, more than 3 consecutive days of leave, then it's probably not the test is whether it's a serious health condition. And so, I mean, like give me an example of.
He comes down with the flu and then he ends up in the hospital with bronchial pneumonia for a month and a half.
Yeah, I think that would trigger it. Yeah, the flu may not. I mean, you don't want to be in a situation where you're extending family not that it's something bad to do, but it's not necessary. If someone has the flu, it's not really a family medical, it's not a serious health condition. But you're right, as it develops. Now the question is, when do you exercise your rights as an employee, or when do you exercise your rights as an employer to provide someone with notice that they have rights under the Family Medical Leave Act? And in that type of situation, if it's flu that develops, it wouldn't be initially because it's flu and you don't anticipate that they're going to have an extended absence from work, but if it develops into something else, I think as an employer, I would take the stance that you should reach out. First of all, I would always take the stance, if any of your employees are sick or hurt, continue to reach out to them to see how they're doing. You would be amazed how far that goes in terms of the recuperative process. But reach out to them and let them know what their rights are in the Family Medical Leave Act. Because the last thing you want as an employee is being in the hospital worrying about your job. Because under the Family Medical Leave Act, you have to preserve someone's job for them if they're out on the Family Medical Leave Act. So that's the reverse for the employer. The employer, obviously if they're a good employee, they want to keep that employee, but they don't want to have to keep a job open forever either. And sometimes it gets into that situation. How long do I have to do this? I get that question all the time. How long do I have to keep them on payroll? Or particularly in a workers' comp setting. Someone's out for 2 years and they'll call me and say, how long do I have to keep them on payroll? I'm like, they're still on payroll? It's been 2 years. They don't go back to work. I guess in that situation, at the point that you realize that it's something more than just the flu, as an employer, I would reach out to that employee or have your Human Resources Department reach out to that employee and tell them what their rights are in the Family Medical Leave Act. They'll need to get a certification that they're entitled to leave under the family. Their doctor will have to certify that they have a condition that entitles them to leave under the Family Medical Leave Act. Because it also inures to the employer's benefit to start that leave earlier rather than later if you think it's going to be a more serious condition, because you, and this sounds jaded and I don't mean it to, but you want that leave to start because you want that 12 weeks to start. Otherwise you're sitting around, you know, months later trying to figure out what you're doing. And for example, in that situation you don't do anything about leave. 4 months in, they're still not back to work and they're still trying to recuperate. Then they come to you and say, hey, I want to exercise my rights under the Family Medical Leave Act. That 12 weeks starts to run then. It doesn't, you can't backdate it. So then you're left with another 12 weeks sitting on the books without an employee there doing the work. Now, again, that sounds jaded. I'm just telling you what the, you know, some of the strategies in terms of this, not to fire somebody, but just to preserve your workforce.
This is kind of a fine point, but I have leave. I've got 6 weeks of, you know, say 10 weeks of leave in my bank account. And so I've been in a car accident. It appears I'm going to be out, say, 2 months. So I got 6 weeks of leave, sick leave. I'm going to take those. Would you, at the same time, because I'm going to be out 2 months, would you trigger that
Yes.
FMLA at the beginning of that, or at the end of where the last 2 weeks kicks in where
No.
I've exhausted my bank account?
No, I would trigger it at the beginning.
So concurrently.
I wouldn't be concerned of how much leave you have in the bank. I would be more concerned as an employer about running that 12 weeks. You can use that leave in the bank. And that may come to a question as to whether, for example, the weeks in the bank, is that paid leave or unpaid leave?
Paid.
Yeah, because that way, I mean, I would trigger it from the start so that, and actually you can tell your employees that they have to use paid leave or vacation or whatever it is as part of this FMLA. So I would start it at the front, because once that 6 weeks is up, or then they still have, their job is still protected under the Family Medical Leave Act for another 6 weeks. But they may not be getting paid after the end of that first 6 weeks. Yeah. So no, if you know it's going to be something, in fact, I think you have an obligation actually to trigger the Family Medical Leave Act.
Even despite the fact that I'm taking sick leave.
Absolutely.
Right, okay.
Because from the law standpoint, honestly, because it says it's unpaid leave, but from the law standpoint, the law is more concerned about protecting the job than about whether you're going to get paid or not, and whether or not you're going to be able to, whether you have enough leave in the bank. You have leave. You have enough leave under the Family Medical Leave Act. Now, whether you get paid or not, that's a function of what benefits you have with the employer. And you know, how many people don't have paid leave? I mean, that's another issue. But the Family Medical Leave Act still gives them some peace of mind knowing that if they're out, and if they come back within the 12-week period, then their job is going to be protected, and the benefits that they've accrued are going to be protected during that time period. And there was a situation I was going to tell you about. Oh yeah, I represented a company. Tell me how smart this is. I had an individual that was out on family medical leave to care for his ailing father, so was clearly qualified under the Family Medical Leave Act. And at the end of the 12 weeks, the father dies. In fact, it was right at the end of the 12-week period. The company has a bereavement policy that gives you 3 days of leave for bereavement. The employee did not ask for the bereavement policy because he was out of work, because he was caring for his father, and then he was dealing with the death of his father. At the end, because the employee did not come back to work on 12 weeks and 1 day later and did not ask for the bereavement policy, the employer terminated him. How many of you would want to take that to a jury? No, it was awful. And I said and I always tell people, if you're in Walmart, look at the 12 people in line behind you. That's your jury. Are they going to buy this? The optics are horrible in that case. That's another case we settled. Because honestly, when I talked to general counsel of the company, he finally agreed and said, this, and plus it makes the company look horrible in the community. Because it was horrible. I mean, who would do that? No call. They knew the dad had died, but no call to the employee to even express their condolences. They just sent him a letter of termination. A letter.
Wow.
What if you are taking care of a parent, and you're basically, they don't drive, you have to do all that, and you request that your employer allow you to have fluctuating work hours, that you may want to do 4 10-hour days and have 1 day a week to where you can take to the heart doctor, to the general dentist, to dermatologist for cancer surgery and all that. Is an employer, do you have any legal right to make that employer go with a fluctuating work schedule if you've got the doctor's signed form that's filled out?
Yeah, I mean, you would have to ask for leave under the Family Medical Leave Act. And, there are 2 types of leave. One is just chunks of time, weeks at a time. The other is intermittent leave. So, yeah, I mean, that's something that may well qualify for intermittent leave under the Family Medical Leave Act. I don't do this because I'm not in human resources, but I know some of you are. That's probably one of the biggest nightmares in human resources is keeping track of intermittent leave. Because you have to calculate all that and figure out when you exhausted your 12 weeks. But once that 12 weeks is up.
No, I mean, though, if you just said, can I have fluctuating work hours, that I work 4 10-hour days, which they get their 40 hours in, and that this day of the week is I'm out, and I'm taking care of my mother.
I think that's going to be tough. Simply because, first of all, is it scheduled, or you just want you want 40 hours, you want to basically lump your 40 hours in 4 days and then take every Friday off?
Well, but most of the appointments we've managed them on Fridays.
Yeah, I think that's going to be pretty tough to do that. Because, I mean, the employer's not going to, I don't know, the employer may do it. It doesn't hurt to ask. But if they say no, I'm not sure you have much of a claim there. Unless it's something that you know is going to be required every Friday. And they'll do that for a time period, but at some point that'll run out when the Family Medical Leave Act runs out. Here's another funny, I thought it was funny, Family Medical Leave Act story. I got a call from a human resources director that said they had an employee that had come in and wanted leave under the Family Medical Leave Act because their cat was sick. And, so we got all kinds. So I said, well, that's actually not covered. So then 20 minutes later, the human resource person called me back and said, now they brought me a note, or 20 minutes, I don't know what the time frame was. It was the same day. They've told me that they have a note from their doctor saying they're depressed because their cat is sick. And now they leave. And I said, well, now they're getting closer. So you have to give it to them for being pretty crafty. Now, we talked about this briefly, but employees may choose and you may require as an employer that folks use accrued paid leave to cover some or all of the FMLA you've taken, and that's something that you mentioned. That includes vacation time as well. You can force folks to take vacation as part of their family medical leave.
I would think that's where, though, having your company policies about your leave time is really going to play a factor in that.
No, absolutely. Yeah.
The company policies can't usurp state or federal laws, so the policy has to match the law, right?
Well, or the policy can be more giving than the law. I think that's as a baseline. But there's no law that says you have to give someone, 6 weeks of paid leave either. But you can. You want to have your policies not geared towards necessarily the Family Medical Leave Act, but geared towards what you want your employees to have. And hopefully that's meets the threshold, at least, of the basic FMLA requirements. But yeah, you can't just willy-nilly make up rules as you go along, and that's where people get in the biggest trouble. You know, and keep in mind, every time you make a decision on an employment matter, you are setting precedent within your own company as to what is going to happen in the future, so what's predictable for your employees. You know, Joe's a terrible employee, so we're going to do this to him, but Gene over here is a great employee, and we're going to treat him or her better. That is a recipe for lawsuits, particularly if you can't document why you're doing certain things. Now, upon return from family medical leave, an employee must be restored to his or her original job or to an equivalent job, which means virtually identical to the original job in terms of pay, benefits, and other employment terms and conditions. And honestly, there's been some case law recently that extends to hours as well, or work schedule. In addition, an employee's use of FMLA leave cannot result in the loss of any employment benefits that the employee earned or was entitled to before using the FMLA leave. So, for example, if an employee, and I'm not the expert on this, but if you pay a portion of health insurance for someone and they have to pay the rest while they're on Family Medical Leave Act, you have to basically continue paying that until they come back. Because otherwise you won't be able to restore them to their regular job. Even if they haven't paid their portion, I mean, you can get it back somehow, but even if they haven't paid their portion, you have to continue that on. Because otherwise they'll be off the rolls, or your insurance rolls. You can't let that terminate. Now, is a serious health condition under the Family Medical Leave Act the same as a disability under the Americans with Disabilities Act? And the answer is not necessarily. An ADA disability is an impairment that substantially limits one or more major life activities. A record of such an impairment, or being regarded, as we talked about, of having such an impairment. Some FMLA serious health conditions, such as cancers, heart diseases, strokes, they obviously would be covered under the Americans with Disabilities Act. Other things, like pregnancy, a broken leg, a routine broken leg, or an appendectomy, things like that, are generally not, they don't fit within the definition of disability under the Americans with Disabilities Act. Those are more temporary occurrences, that it's not some prolonged disability. Now, one of the questions that, you know, employers honestly are generally scared about what they are and are not allowed to ask their employees in terms of disabilities, or for obvious reasons. But someone comes to you requesting certification under the under the Family Medical Leave Act, then all of a sudden they've given you information that may lead to questions about whether they have a disability under the Americans with Disabilities Act. That is very important. I would not put blinders on and limit your inquiry at that point to, you know, someone says, I'm not smart enough to even make up an example, but I need leave under the Family Medical Leave Act for whatever it is. You as an employer need to be mindful enough to know that that may trigger some responsibility that you have under the Americans with Disabilities Act. Because they may be asking you for leave under the Family Medical Leave Act, but generally employers are more sophisticated than the general employee about some of these acts because you've had training in it. But you should know that their request for leave under the Family Medical Leave Act may actually be a request for accommodation under the Americans with Disabilities Act. So keep in mind, it's not one or the other. One may trigger the other, and you need to be very mindful of that and have some basic understanding as to what your responsibilities are. Does that make sense? Is that scaring everyone enough? You certainly have a right as an employer to know why someone is asking for leave under the Family Medical Leave Act. fact, they have to send you a certification as to why they need the leave, and it's certified by their doctor. Now, one thing I would do, whether it's Family Medical Leave or the Americans with Disabilities Act, or even workers' comp, I would maintain different file. You have a personnel file for your employees. Do not put their medical records in that file. Maintain a separate file for medical records. That's pretty critical. Because otherwise, and I know it seems like it's semantics a little bit, but from an EEOC standpoint or from a Department of Labor standpoint, if you're commingling those records, their concern is it leads you to view those folks differently, and it leads you to potentially discriminate against those folks because all that information is together. Keep a separate medical file, and also keep that separate medical file secure because you don't want anyone else getting into that file. Now, let's talk about work. Let's backtrack a second and talk about workers' compensation. And so I'm not talking about ADA or FMLA. I'm just talking about workers' compensation. Someone gets hurt on your job site or at your job, and let's say they break their leg. I don't know. I'm just making something up, and so you have insurance. Let's hope and pray that you have insurance. Let's hope you have good insurance, which is also critical. But so you report that to your insurance carrier, and they handle the workers' compensation aspects of it. In terms of, and workers' comp provides for medical benefit. First of all, as a